Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, a couple of days ago, we dropped this video right here, and it had to do with a large, huge, and ever-growing rumor mill that was kicking around primarily on Reddit about how Justice Amy Coney Barrett was this close to not only issuing an injunction which would stop implementation of all of Illinois' assault weapon ban, but she also, with the stroke of a pen, could strike down all assault weapon bans. Now, we did that video not because we wanted to chime in and say, yeah. We did that video because that wasn't actually the case, and there was a lot of hyperbole and conjecture going on, and we wanted to correct the record. Well, as we know now, Justice Coney Barrett has decided not to issue an injunction on that case and is going to let that case ricochet around in its normal course in the Seventh Circuit. That has people on both sides of this issue completely overreacting. So let's bring everything back to reality again. Let's slow it down for a second and let's have a discussion about what does Justice Barrett's denial of the Illinois injunction really mean to all of us. Okay, so the issue that we are talking about now for the 134th time here on Washington Gun Law is Illinois' assault weapon ban. Now, Illinois, I will remind you that we are undergoing the same type of pain and agony here in Washington that you are undergoing in Illinois, so we do feel your pain. Now, as we know, there was an assault weapon ban passed in January of this year by the state of Illinois legislature. Started off as an innocuous piece of insurance legislation, turned into a full-blown assault weapon ban in 72 hours. Prior to that, we also know that the city of Naperville had decided to do their own assault weapon ban back in August of 22, and that had Rob Beavis and everyone over at Law Weapon completely sideways at that point. As we also know, there was all sorts of ricocheting around in appellate courts with injunctions that were on again, off again, and so forth, and things finally settled on the Seventh Circuit. Now, the Seventh Circuit decided to stay the injunction that had come out of the Southern District of Illinois, which means that that 5 days of freedom that everyone was enjoying there has since come to an end. Here's the issue. The plaintiffs in one of that cases, the National Association for Gun Rights, decided to throw a bit of a Hail Mary pass and actually appeal the stay of the injunction to the United States Supreme Court. And knowing that this was coming out of the Seventh Circuit, counsel obviously knew that this would get before Justice Coney Barrett. Now, that began the rumor mill flying that she had a chance to completely undo all assault weapon bans nationwide. And we talked about why that was not really the case. Really, what she had was two choices, okay? Either go ahead and re-implement the injunction and join the law until this matter resolved itself, or just keep her hands off, let this thing percolate through the system as it should, and likely would end up in front of her at a later date. She has chosen the latter, okay? She has chosen not to re-implement the injunction. Now, that has people, as I mentioned earlier, on both sides of the fence completely freaking out. For all of those of you in the 2A community, yeah, many of you got your hopes up way too much. You believed that this hearing had a little bit more importance than it really did, and you were probably misled by other individuals who candidly didn't quite understand the posture, the procedural posture of the case at that particular time. And so what I'm here to tell all of you is this the end of the world? No. Is this a bad sign? No, it's not. And we'll explain why in a moment. Now, for those who support this legislation, in particular State Representative Bob Morgan, who I am not a particularly big fan of, he was on Twitter right away proclaiming their success as follows. Justice Coney Barrett's decision reinforces what we already knew, that the Protect Illinois Communities Act is, by design, constitutional, and that it comports with legal precedent. That this ruling comes from a member of the court's conservative majority without noted dissents is the clearest indication yet of the strength of this life-saving law. The Protect Illinois Community Act has already prevented the sale of thousands of assault weapons and high-capacity magazines in our state. This ruling is a victory in the fight to keep these weapons of war from creating more carnage in the communities like mine and countless others across this state. And I would say to Representative Morgan that you have also, like many in the pro-2A community, completely read way more into this than should be. Why did Justice Coney Barrett decide not to issue the injunction? Well, nobody knows for certain, but if you take a look at the briefing schedule that the 7th Circuit has announced and how quickly they are going to force both sides of this issue to get their briefs in, and that this issue is clearly going to be litigated and come to a head really quick. And when we talk about moving at legal light speed, I get that still is weeks, not minutes, but this case is moving along. If the briefing schedule remains, this case is coming to fruition in the very near future. It is my belief that for that reason, Justice Coney Barrett, rather than take the very extraordinary step, and it would have been an extraordinary step for the Supreme Court to step in on an interlocutory appeal. What's an interlocutory appeal? Well, that's a fancy word for just appealing in the middle of the case. It would have been an extreme measure for the Supreme Court to step in, knowing that this law was going to be fully litigated and could end up in front of the United States Supreme Court as early as the next term. It is my belief that that is the reason that Justice Coney Barrett felt it was best for her and the court to keep hands off for now. But as I mentioned in this video right here, for those of you who read Stephen King's The Stand, there is 1,000 pages of a story before you get to the punchline. Well, folks, we are through those 1,000 pages, and we are coming up now to the ultimate battle where we will decide this issue once and for all. When you take a look at the hodgepodge of rulings that we're going to end up with throughout this country, especially when Judge Benitez's ruling comes out as well, there is no doubt that this issue will finally be completely ripe for Supreme Court review, and candidly, the Supreme Court will have an obligation to accept review. The bottom line is this. For those of you on the pro-2A side, should you be freaking out and finding the nearest bridge to go jump off right now? No, you should not. For those of you who are interested in stripping the citizens of their otherwise inalienable rights, don't get your hopes up too much. Don't read too much into this, because there are many painful days still left for you, I can assure you that. Listen, you may have more questions about what Justice Coney Barrett did, what's going on in Illinois, or anything else related to what's left of our Second Amendment rights. You guys should know how to contact Washington Gun Law by now, but if you don't, that's okay, because that information is right there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.